Good evening. I'd like to call the special meeting of the Governing Board study session to order at 7:06 p.m. Please let the record reflect that all board members are in attendance. Do I have a motion to adopt the agenda?
So moved.
I second.
Thank you. I have a motion and a second. All those in favor, please say aye.
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 Aye. Any opposed, please say nay. Hearing none, the motion passes unanimously. We will have a presentation on board member roles, responsibilities, and legal compliance based on board members' requests at a board meeting in September. We've added this meeting to our schedule. I'd like to welcome Denise Lowell-Britt and Rob Hawes, attorneys for the district, who will be doing a presentation that is about 40 minutes. During the presentation, we are going to let them finish their entire presentation, and then after that, we will allow board members questions that we'll give each board member about 6 minutes to have their questions so that we have time for wrap up at the end. So with, no, please proceed. I'm not sure which one of you is starting. Okay, Mr. Hawes, thank you so much.
Thank you for the opportunity to be here tonight, President O'Brien, members of the board, Dr. Finch, and look forward to sharing some information with you that will hopefully be move forward. Just by way of disclaimer, we are not going to be giving the board specific legal advice on pending matters tonight. That would be covered by the attorney-client privilege. And so we're going to be giving more general legal information as we go forward.
Thank you. And I just didn't remind our board members that you actually have a packet that has their presentation in front of you so that you can take notes and write questions as we go, just so you can remember what specific slides maybe they're attached to. I apologize. Thank you, Mr. Hawes.
Thank you, President O'Brien. And along those lines, I will not be reading my presentation to you. I assume you'll look at it and have had a chance to familiarize yourself with it. I'll be happy to emphasize a few things that I think are important and answer questions at the end. So we'll start off with the gold standard here of board member roles and responsibilities, which is all for one, one for all. The more we are together on things, I think that's in everyone's interest. Your policy, you have a policy, BBAA, that talks about board member authority and responsibilities, and it emphasizes that individual board members exercise authority over district affairs only by way of votes taken at a duly authorized meeting. And we've cited to an Attorney General opinion that emphasizes that you as an individual have no power or right different from any other citizen, notwithstanding the statutory powers that you are able to participate in exercising when you are part of the board. The staff will certainly give you deference, probably more so than the standard Joe off the street that wants information from you, and they respect your role. But as an individual board member, you have no power or right different from any other. All of your board power lies in your action as a public body. You are 1/3 of the way to getting your way on whatever comes before the board. And it reminds me of the saying that if you want to go fast, go alone, but if you want to go far, go together. So as you think about your individual efforts on behalf of Deer Valley or on behalf of the interests that you support, I think realizing that all of your powers lie in the public body, you should ask yourself, do I need to speak about this? Do I need to write about this? As an individual that has not been tasked with that by the board. If so, you should, in my view, issue a disclaimer to people that are going to be reading or listening to what you have to say, that you are not acting on behalf of Deer Valley Unified School District. This is your personal opinion, and the district may think otherwise or do otherwise. Some scenarios where individual action arises frequently is when you're being interviewed by the press, when a constituent wants to request that you take particular action, or you make promises or commitments to constituents that you individually are not able to make. When you go to visit a school, again, you as an individual board member, unless you've been tasked by the board to do that, you are in the same capacity as anybody else visiting that school. And you're obligated to check in, let people know what you're doing. You may need to check in with the superintendent's office ahead of time as well. Dealing with vendors, again, you have no authority to commit, bind, on behalf of the board. And social media is becoming an increasing point of concern in this area, and Denise will cover that in more detail. But again, I think it's important that if you decide, I need to speak about this, I need to write about this, as an individual, that you should issue a disclaimer that the opinions are your own. You are not acting on behalf of the school district. Arizona's education code sets out a school board's authority. You are, as a political subdivision, you're a creation of the state. You only have the authority granted to you by the state. And there's two main statutes that deal with that. One is 15.341 that provides a mandatory list of things that governing boards must do, and 15.342, which is a permissive list of things that you may do if you choose to do so. Your policy BBA talks about board powers and responsibilities. And the area that I want to really try to emphasize on this is that you are to accept the responsibility for confidentiality in appropriate matters, especially those dealing with personnel, student issues, and legal matters. The divulging of privileged information that could cost the district money, support, or public confidence, that is not a decision that your policies have decided that you alone can make. For example, the attorney-client privilege, that belongs to the board as a whole, and it is not up to one individual board member to decide if they are going to waive the privilege. You'll get advice on a whole variety of things during your time on the board, and that attorney-client privilege exists for a lot of very good reasons, and it is the privilege, it is the board's privilege to waive. You can waive it if you think you should, but an individual board member does not have the authority to do that. This policy BBA, talking about board powers and responsibilities, also, again, these are the rules that you have set for yourselves. Indicates that you will refer complaints to the proper school authorities and refrain from individual counsel and action. Now, you may ask yourself, well, why? Why shouldn't I get more involved in a matter, investigating, looking into a matter that comes to my attention? I'm really interested in this point, and I may not have full confidence in the person that I think is going to be following up on this. Why should you defer to this policy and refer complaints to proper school authorities? Again, you as an individual have no authority to act on behalf of the board, and many of these things may come back to the board for a vote on a later time. For example, a personnel item, whether somebody should be fired, whether a student should be expelled, whether the district should settle litigation. All of those matters will come to you in due time. When those matters come to you, such as when you're asked to decide, should we fire somebody? Should we expel somebody? And those sorts of things, you act in what's called a quasi-judicial role, and the person whose fate you are deciding that evening has a legal expectation that you would be fair, impartial, and open-minded. And to the extent that you've engaged in an independent investigation, to the extent that you've not referred this to the proper school authorities, that person could question your open-mindedness, your impartiality, whether you've prejudged these facts and already made your mind up, or made your mind up on information that's not available to the entire board, or that person has not had a chance to challenge. And so you may jeopardize your ability to vote if you get too involved in these sorts of things. And so referring complaints there are a lot of reasons why you want to do that. You will get to vote on things ultimately. And if you'll let the process run its course and be patient with that, then you will ultimately have the final say. If you get too involved in it, you may lose that opportunity, and you may compromise the district's interest as it goes forward. You also have a board policy that talks about ethics. Again, the rules that you've set for yourselves on these things, and your decisions should be made only after discussion at publicly held board meetings. This ethics policy also says that you will take no private action that will compromise the board or administration, and respect the confidentiality of information that's privileged under applicable law. So what does that, how do we get crosswise or off course on some of these things? Sometimes people will offer their opinions on legal matters. They will offer their opinions on legal liability. And if you as an individual board member are saying, I think the district is liable because of this, or I think the district was negligent because of that, in a courtroom, you're not qualified to make that decision, for starters. And for two, that may be inconsistent with the position the district actually needs to take, wants to take, and is supported in taking by the full amount of information that would be revealed during the course of an investigation. So offering your legal opinion, offering your thoughts on legal liability on matters, whether somebody has complied with the law, whether somebody's defamed this person or that person, whether somebody's breached a contract, whatever it may be, again, the rules, the ethical rules you have set for yourselves indicates that you should refrain from that, and with good reason. Board policy BHD, board communications with the public. You have tasked the superintendent with the role of imparting this information, communicating with the public. And the more voices there are on a particular matter, the more risk there is that those voices will be inconsistent, incompatible with one another. If your superintendent is not doing what you think he should be doing, you can evaluate him and hold him accountable. But your policy is that he will communicate with the public. And to the extent that you do that, again, as an individual, unauthorized by the rest of the board, you undermine his authority. You undermine your administration's authority to do what you've hired them to do and to do what you've committed you want them to do. The board superintendent relationship also addressed by policy, and you set policy. These are your rules. If you want to change them, have at it. But once you make the rules, I think people fairly expect you to follow them. Rules for me, but not for thee. We've all heard that, and that's a challenging scenario. And so you can make your own rules, but once you do, you should follow your rules, because when you make a rule and don't follow it, then you're exposed on a person saying, well, that's not the way it was supposed to go. So you make your policies. The superintendent is the chief executive officer. He enforces the policies. And you get to evaluate the superintendent as set out in your board policy. You as an individual board member are not a backseat driver as to how the administration is doing its operations. Again, your voice is when you evaluate the superintendent. And you can do that as often as you want by policy and by his contract. And you can communicate with him as often as you want. But again, that's the rules you've set for yourself. And you may say, why is that so? And the Attorney General's opinion on this, quoting from a longstanding case, is that the law contemplates that members of the school board are interested in education, interested in children, but may not have all the professional training and expertise of the staff that you hire. I know some of you do have that specialized training and expertise, but still, you don't have the full-time effort to devote to this as the people that you hire do. And so that is why the Arizona recognizes that the members of the board supervise the professional work, but that the superintendents, teachers, principals have exclusive control over those matters. And I'll turn the time over to Denise.
Thank you. All right. Okay, so I'm going to talk a little bit about board member accountability and then move into board member use of social media and email. So kind of tagging along to what Rob just finished sharing with you, board members, as he noted, are certainly expected to follow your own board policies, and board members are expected to adhere to all applicable laws and governing, as I said, governing board policies when you accept your office. And I think board members really do strive to do that. It can be complicated sometimes. Laws are complex, and you have a lot of policies to get to know. But that is the general expectation and commitment that board members make when they take their oath of office and start serving on the board. There are a couple of different policies, in addition to the ones that Rob mentioned, that are relevant to this topic. In terms of the board president's responsibilities for the orderly conduct of meetings, meetings are, again, where you have all your power and your authority. And in the case of the board president's role at board meetings, that you have a policy that basically provides the board president with the ability and the responsibility to preside over those meetings. So in your policies, it provides that the board president shall preside over all meetings and conduct meetings in accordance with Arizona law, district policies. The board president is charged with encouraging and maintaining orderly and democratic participation. Conducting, again, an orderly meeting. That term orderly comes up a couple different times in the policy. And then also the ability and authority to rule on the appropriateness of the subject being presented. And to that point, you, of course, have board policies that also talk about how you generate your agendas. And then we have open meeting laws that dictate that you should only be discussing matters that are on your agenda. And so part of that responsibility is to make sure that as the meeting progresses, board members or others who are invited to speak during the meeting only speak to those matters that are on the agenda. And even under call to the public, again, special rules concerning that. Under calls to the public, board members may be permitted to speak to matters that are not specifically on the agenda, but that's why the open meeting law also indicates to you or directs you to have very limited responses in the case of call to the public, because of the need to ensure that the public generally knows what topics are going to be discussed and considered at any given board meeting. Regulation of board member misconduct by the board. Certainly, in the last year or two, we're living in some pretty challenging times, generally across the nation and certainly in Arizona. And sometimes members of the public are unhappy with something that occurs vis-a-vis a particular board member. And sometimes what happens is a community member will communicate to the administration or to other board members, I'm not happy with the conduct of that board member. You need to do something. We want you to censure that board member. We want you to, remove that board member. And it happens. And what the public doesn't understand oftentimes is that in Arizona, board members do not have the ability to investigate or discipline or censure each other. Okay? There may be times third parties are charged with investigating, but within a board, there's no statutory authority to do that. And in this Berry v. Foster case that's now been around for some time, the Arizona Court of Appeals made it clear that board members cannot censure or discipline one another for improper conduct. So what does happen if there is an allegation of board member misconduct, well, there may be, as I said, third parties that can come to bear on the issue, who may impose consequences if there's established, proven misconduct, or who may investigate, in some cases, alleged misconduct. We have the Arizona Attorney General, for example, that can investigate allegations of open meeting law violations. The courts may come into play. And certainly the qualified electors of any district has that statutory ability to seek a recall election of a board member if they're not pleased by that board member's conduct or actions. And then kind of in an indirect way, and Rob, talked super briefly, but about kind of, you will be talking more later about insurance coverage, and I'll touch on it a little bit in my next portion of the presentation. But in an indirect way, your insurance provider may also have the ability to weigh in when a board member kind of acts beyond the scope of their authority to the detriment of defense of the school district by withholding coverage of a particular board member. And I think we're both going to be talking a little bit more about that. So I'm going to move on to board member use of social media and email. And even though I think most of my slides are focused on social media, many of the concepts are also going to apply to board member use of email. So, okay, so the first thought is, and the way I tried to frame this portion of the agenda is, if I were a board member and I wanted to use social media because I felt it was a good way to communicate with my constituents or the public, and certainly there are good reasons why board members may want to use social media, I would ask myself questions as I was thinking about posting to make sure that I never kind of cross the line from appropriate use of social media or email into improper or dangerous or potentially just risky uses of social media. So the first thing that a board member may want to ask before posting is there a potential for my social media posting or my email communication to constitute an actual meeting, a board meeting under ARS 38431? So to that, we have to look at the definition of meeting under the open meeting law. And from the statute, we know that a meeting means either a gathering in person, which we all, like tonight, you're all here, or through technological devices of a quorum of the board, at which the members discuss or propose or take legal action, including any deliberations by a quorum with respect to that action. And then it goes on in the law to further define what this meeting could look like. So a meeting can include a one-way electronic communication by one board member to a quorum of the board that proposes legal action. This is probably the most risky aspect of this, because if you all, and I'm not going to say you, if board members are actually looking at one another's social media postings regularly, so if at any time for any board, if there's a quorum of the board who's regularly looking, at each other's social media, and one of those board members is actually using the social media communication to propose legal action, that and the other two board members are looking at it, that places everybody at a risk situation. The second, and these are all ors as I walk through them, but and this is all coming from the statute, a meeting can be an exchange of electronic communications among a quorum of board members that again involve discussion, deliberation, or the taking of legal action by the board concerning a matter likely to come before the board. In this AG opinion, now this actually, I think, predated the update to the statute that I just talked about. But it noted board members can send information to other board members, but there can be no discussion concerning the information until and unless it then becomes the topic of a public meeting. And there's a number of AG opinions at this point that talk about this technological use of communication among board members, and there are some good examples to be had in those AG opinions. And another aspect of use of social media and open meeting law, in my view, has to do with executive session discussion or minutes, because board members, you may be having, extensive executive session discussion, but then, you may be able to, but then there may also be the topic being discussed in the open meeting. And sometimes you may not recall, did something happen, did the discussion happen in the executive session or the open meeting? And so the danger here is that, we know that the open meeting law requires that discussion occurring in the executive session and the minutes of any of that discussion be kept confidential. But what has happened on occasion is that a board member in their use of social media gets confused or forgets that the discussion that they're posting about wasn't in the public meeting. And there's an inadvertent disclosure of executive session content, and then, that's a technical violation of the open meeting law. Well, it's an actual violation of the open meeting law that could create problems. So, just to put a pin on the point, I guess, any use of social media that refers to or replaces executive session discussion or is a violation of the open meeting law. And, some boards, I don't know how many, especially because you all use, and I mean, not just you here, but generically board members these days are often using their laptops or for content to be, discussed during an executive session. But there are some governing boards in the state that actually prohibit board members from having tablets or cell phones in executive sessions just to ensure that confidentiality. So another aspect of use of social media has to do with copyright law. So again, if I were a board member and I was contemplating using my social media to post content as a board member speaking to my constituents, the public, I would want to ask myself, does the posting contain any copyrighted materials, including photographs or articles? Did the board member, and this really applies not just to board members, but all of us who use, social media, did the board member obtain permission from the copyright holder before posting the content? Or does the posting violate the copyright owner's reprint or use guidelines? There's just this sense, I think, in many people that if you find it on the internet, it's open for use. And the copyright doesn't apply, but that's just not true. So you will always want to make sure that if you're going to be reprinting, reposting, that's something you think about. Another aspect of social media use is student privacy. So we'd want to think about, does this posting contain any FERPA-protected information, Family Educational Rights and Privacy Act, that you're familiar with, that governs parent and eligible student access to the records, but also provides a lot of protections and confidentiality about those records unless consent has been given for the release of that personally identifiable information, or unless some statutory exception under FERPA applies. So we want to make sure that there's not a violation of FERPA by posting information that you know because you had access to a student's educational records, or that the third bullet here is about personal information the family expects to remain privacy. So even if you are posting something that's not an educational record, you may also come into information as a board member that is being provided to you but should still be confidential outside of FERPA. And an example of this that occurred a number of years ago is that the board members became aware of a student who had been in a serious accident and the nature of the injuries and, just details about the accident and the condition of the student. And just very, the board members trying to be kind and thoughtful in a way, but shared out what had happened and kind of like, we're so sorry to hear this and we wish you the best, and, just trying to be kind. But the family became extremely upset. They did not authorize the release of the information, even if it wasn't technically FERPA-related information. It was not expected to be shared publicly. So just having that awareness when you post is important, because that could damage relationships, obviously, and lead to distrust. And then defamation, social media and defamation. So if we're going to post something, we want to make sure, that we have done our research and make sure that anything we're posting is factually accurate. So you would be thinking of the question, does the posting contain a defamatory statement? What is a defamatory statement? It's when one publishes to a third person a false statement, either by insinuation or explicit statement of or concerning another person that tends to bring that person into disrepute or contempt or ridicule. Okay. Next consideration on posting is, does the posting constitute a breach of contract? How might this come into play? Well, although we don't see it all too often, there may be, for example, severance agreements that contain a confidentiality provision that says the district won't share information unless required by law, to do so, something like that. So it could be a breach of a severance agreement to share out information. Insurance contract, I think, Rob, you're going to maybe talk a little bit more about that, and I think, going to talk a little bit more about that. But it's essentially, we've got cooperation clauses in your insurance contract, and all of us probably in our personal and automobile, all kinds of insurances that says, hey, part of our agreement with you is that you're not going to make it more difficult for us to defend you should there be some kind of litigation. And depending on what you post, you already kind of did talk to this a little bit, Rob, which is to say, if you were to announce publicly in social media, whatever, that, hey, we've known about that hole in the ground for months, and why didn't our groundskeeper do that? And then after someone has fallen in the hole and injured themselves, that could be a problem. And then there may be other kinds of contracts, again, that may come into bear. So we want to make sure that before we post things, we are not inadvertently violating any of the district's contracts. And Rob, you also talked a little bit about this, due process protections. When we're posting on social media about personnel matters or student matters, grievance hearings that may come before you, you may, as Rob said, compromise your ability to act when it's the most important for you to act, which is as a board in that kind of judicial capacity when you're acting as the judge and jury over a matter. We want to think about, would a posting that I make about this matter impact my ability to discharge my duties in an evidentiary hearing? And so we know from your board policies that certain grievances may come to you ultimately if the grievance isn't satisfied at the lower levels. For your employee discipline hearings, only the board can terminate an employee that has an entitlement to a hearing right, due process. And then, of course, the board is the only entity that can expel a student. And if a student is long-term suspended, they may appeal to the board. So those are examples of where you have such important responsibility, and you don't want to compromise that by, as Rob noted, posting in a way that will cause people to believe that you can't be fair and impartial. And whether you then feel you have to recuse yourself or you're asked by an attorney representing the employee, or in some cases the administration, you may be asked to recuse yourself. and this kind of follows along with that there may be a perception, even if it's not true, or a reality that the board members prejudge the matter and won't be fair and impartial. And it could certainly be used to challenge the validity of the board's decision if the board member does not recuse him or herself. And then public records law. Social media could constitute a public record in some circumstances. So we again have to look at what the law says about the definition of a public record. And a public record can include those records reasonably necessary and appropriate to maintain an accurate knowledge of your board members' official activities and publicly funded activities, made in pursuance of a duty to disseminate information to the public, made to serve as a memorial of official transactions, required by law to be kept, or other records, and that term can be construed broadly. The first bullet is the one that may be more likely to come into bear when you're posting individual, as in your capacity, meaning you're doing it because you're a board member and you're putting it out there as a board member talking about board member business. And the determination of whether something is a public record or not is based on the content of what's posted, not the format or location. And so what does that mean? It means that use of a personal iPad or a personal phone, that's not definitive as to whether or not content on the personal phone or the iPad could be accessed, or that items on those personal items can be accessed or must be disclosed. It's really, does the content arise to the level of, or the definition of a public record? And so that means that there are some cases where board members would have to actually maintain their social media content, text, those kinds of things, if they meet the definition of a public record. Okay, I'm going to turn it over to Rob again.
It's a very interesting time to be a board member. So thank you for your service, for starters, again. But it's just an emotionally charged time to be on a school board, and so we hope this is helpful to you as you undertake your duties. I know you've recently had training on open meeting law from ASBA, so I'm going to kind of skip a couple of these slides, and I know you're all A+ students and you'll read on your own outside of class. But a couple of things I want to point out and emphasize what Denise said. Great advice to be mindful of serial discussions, whether that's an email chain. I talk to you, you talk to me, I get your text, I forward it on. You don't know, when you forward it, that recipient doesn't know how many other people have been involved in the discussion. There's these serial communications have high risk for open meeting law problems. And again, if you take an action in violation of the open meeting law, the action is null and void. It's as if it never happened, and there's stringent things you have to go back and do to try and fix that. These serial discussions, whether it's by phone, in person, email, text, all of that counts. And it doesn't matter whether you're using a district-provided communication device or address or a personal communication device or address. If it goes to board business, it would be considered fair game when reviewing the open meeting law. All right, so despite your best efforts, not everybody's happy, and the people that are unhappy are more likely to show up than the people that are happy at your meetings. So if you feel you've been challenged or criticized unfairly after a call to the public, what can you do? Because you're constrained by your agenda. People need to know what you intend to talk about, what you intend to decide. That is why you have an agenda, so that I can think, yeah, I'm going to go to that. I want to hear that. Or I've got better things to do tonight. I'm going to, I'll pass on that. And so call to the public, because no one knows what's going to be said. you are limited in how you can respond. But if you can respond to criticism made by those who have addressed the public body. You don't have to just say, thank you, sir, may I have another, and wait for the next person. You can respond to criticism. That's fair game. You can ask staff to review a matter, or ask that a matter be put on a future agenda. If somebody raises an important point, I don't know, pick something that could theoretically come before you, critical race theory, vaccines, masks, if something like that, you can ask staff to review the matter or ask that it be placed on a personal agenda. But even though you think it is the most interesting topic in the world that comes up in Call to the Public, you are limited to those 3 responses. Okay? And you can't get around it by asking Dr. Finch to do something you're unable to do, or Sheila, because she's so capable and efficient and helpful, you can't have her do something you're unable to do. It doesn't work that way. And you would be responsible for that. Executive sessions are limited to items set out by statute. And when you go into executive session for one reason, you need to stay on topic. Okay, how do you for example, you go in to talk about a personnel matter, and you get to the end of the personnel matter, and then there's a tendency to want to talk about more global issues. Well, did that happen somewhere else? Or this is a recurring problem. What are we going to do about it? You kind of mushroom out the discussion. And so when you go into executive session, stay on topic. Okay, I want to talk about insurance coverage. Ultimately, the school district is liable for almost all school actions. You ran to do great things, and we all applaud you and appreciate you for that. When the district is sued, you're going to be sued, okay? That's the good with the bad on that. You will be indemnified in many instances by district insurance coverage, meaning, you don't have to call up your homeowner's policy and say, hey, I got served with these papers, what do I do about that? Or, call your lawyer and say, I'm in trouble. The district will indemnify you in many instances through its insurance coverage. And state statute provides immunity to you for certain actions. You are immune from personal liability for actions that you take in the scope of your board member authority. And remember, we talked about that earlier, what scope is. If you're acting on your own, you're on your own. If the authority is acted upon in good faith, okay, you all think you would have acted in good faith, and Denise and I would absolutely agree with you on that point, but other people may not. They may think you acted with a bad motive, and and then we have a horse race. That's what court cases are all about. Somebody saying you acted in bad faith, you say I acted in good faith, and the judge and jury need to decide. So just your state of mind, your subjective view of whether you were acting in good faith is not the determinative factor on that. And was this during a duly constituted regular or special meetings? So those 3 categories you should check to make sure you can check those 3 boxes when you're talking about statutory immunity. For federal claims, there's also some immunity from federal claims as well, and basically tracks same areas as state. Okay, there are 4 specific areas of potential personal liability. One is open meeting law violations. You can be personally responsible for that. 2 is conflict of interest issues, and I'm not going to spend a lot of time on that. If there's questions, I'd be happy to address that. The 3rd area is using school resources to influence the outcome of an election. If you do that, you are exposed to personal liability, and this statutory immunity would not extend that far. And your insurance coverage, as we'll talk about, may not extend that far. The fourth area of potential personal liability is matters outside statutory immunity and excluded by insurance, okay? You spend a lot of money on insurance, and you are well insured by a very good insurance trust. And they actively defend you in a whole host of variety of matters, and they have very capable counsel that are there to assist you. And so you can rest comfortable in a lot of ways on that. But insurance doesn't cover everything. And the insurance coverage contract contains a cooperation clause, meaning you have to cooperate with your insurance company. If you're going to expect them to defend you and ultimately settle something in the event things weren't done right or it makes economic sense to settle it, you have to cooperate. And if you fail to cooperate, you're jeopardizing the insurance coverage, jeopardizing their obligations to you. You could violate that cooperation clause by making unauthorized comments that may negatively impact the district's defense and litigation. I think we're liable. Gosh, we messed up here. We're negligent there. We breached that contract. Those kinds of things that are not your ultimate decision to make, and you don't have the expertise to make it, can jeopardize you and others. So the risk of unauthorized individual board member action. When you're acting as an individual as opposed to acting with your fellow board members, you may not be afforded the coverage that the carrier, if the carrier is sued as a result of unauthorized activities. And this is not to make you unduly scared or nervous. It's to educate you and to remind you, because you're involved in a lot of emotional situations, a lot of critical things, and this is an interesting time. And so we want to try to highlight this. So some other things about insurance. The carrier has the right to make inspections at any time. That includes your papers, your documents that you've generated in your role as board member. This inspection right is very extensive if it needs to be. They can investigate any event that may involve the insurance, your actions, who you talked with, what you said, what's been going on, all that sort of thing. And you're obligated to cooperate with the carrier in its investigation, settlement, or defense of a claim, or you run the risk of not having that coverage. They need to be able to count on your cooperation to set their rates and all that sort of thing. Common exclusions from insurance policies. Plaintiff's attorney's fees. In Arizona, oftentimes the prevailing plaintiff can recover reasonable attorney's fees from the defendant. That award of plaintiff's attorney's fees is generally excluded from an insurance policy. Now, the district may pick that tab up on your behalf. It may not. Depends on the circumstance. But plaintiff's attorney's fees are commonly excluded. Breach of contract claims are also commonly excluded from insurance coverage. Insurance coverage typically covers personal injury, bodily injury, those sorts of things, but breach of contract claims are excluded both as to coverage, providing a defense, and as to damages. Intentional acts also typically excluded from insurance policies. What is an intentional act? Discrimination, for example, is oftentimes viewed as an intentional act. And anything with punitive damages would involve intent. Punitive damages are also commonly excluded from insurance coverage. And under the federal civil rights statutes, which is the most likely statute that you would be named as a defendant in, violation of due process, violation of free speech, religious exercises, those sorts of things, if you are individually named and found individually liable and liable for punitive damages, those would typically be excluded from your insurance policy. And so you have skin in the game on these topics. And if there's any questions about what insurance covers or doesn't cover, we can get you those answers. And we will get you those answers so that you're as secure in doing what you're secure in your office as we can help you to be. But even though we buy insurance and you've bought a lot of it, it doesn't cover everything or everybody in every instance. Also, indemnification, meaning you've agreed to pay somebody else's tab. That's basically what indemnification is. You've agreed by contract to defend, indemnify, and hold harmless the superintendent from legal claims brought against the superintendent in his individual or official capacity as agent and employee of the board while acting within the course and scope of his employment. All right? So to say that the superintendent screwed up, in your opinion, you may feel good about saying that. And if that's true, you've already agreed to indemnify him on those sorts of things. And so, again, another reason to, you can ask any question you want about any legal issue you want, but it should be done in executive session and done as a group so that everybody gets the same information at the same time and you can fully understand your risks moving forward. With that, we'll be happy to answer any questions.
Thank you so much, both. Mrs. Paperman, and we're going to use a timer because we have a hard stop at 8:30. So are you taking care of that, Mrs. Taylor? Let's do 5 minutes because we went a little long. Okay, go ahead.
Well, my question, well, thank you for the information. This is great information as a board member. My question is, I know social media is like a big one. As a board member, when we have sessions, do we post information of an individual board member or individual person within the district? Does that go out to the community?
I'm sorry. I couldn't quite get the beginning of the question. When you're using social media?
Yeah, can I post an individual, like on boards or individuals from districts or, if can I say something about the individual and post information of my opinions of them?
So if you're asking if you can use your social media to publicly post your opinion about a school district employee?
Or board members
Or a board member?
Yeah.
Yes, you can. However, again, you just always want to bear in mind all the caution points, right, that I made. So you want to make sure it's truthful information, but you want to remember your board role and responsibilities. So is that going to be in the best interest of the district? I mean, think back to the board policies that Rob reviewed and then all the questions that you'd want to ask yourself, right, about the risks, potential liabilities of doing so. So if you're going to say something negative and perhaps damaging to that person's employment or their reputation in the community or the trust and confidence that families have in their teacher or their administrator, I mean, the answer of can you is yes. Should you is very different, right? And what risks and liabilities you're creating and what potential harm are you doing to the district, to your students generally, those kind of considerations.
And I'll piggyback off of that. The district has an active social media profile.
Right.
And if you could just, one thing you could do is talk to whoever runs the Instagram account or whatever and say, hey, I think, so-and-so did a great job. Can you maybe think about, giving them an attaboy, attagirl kind of a thing? So you can use the district social media team as well.
And by the way, on a positive note, one of the best things the board members can do with the use of their social media is to link to all the positive. I mean, your district's website, right, or social media presence is awesome. And if one of your goals is, again, to promote the district, to promote its programs, to celebrate its students, to celebrate its activities, to promote the good things the board has done, one really easy, very good way to do that is just use your platform to share out. Please check out the district's Facebook. Check out the district's website. I mean, that's a wonderful way to to use your social media.
Okay, thank you.
Is that all you had? Mrs. Paperman? That's it? Okay. Mrs. Fisher? Mrs. Reed?
One thing that wasn't covered, and maybe you can write something up for us later, was hostile work environment claims, as far as how that might affect the board. I don't know if there's anything that you want to say about it now, or if you just want to kind of file it away.
Oh, go ahead.
I can address that. Again, we're not here to talk about specific situations and give you legal advice on specific matters, but a hostile work environment claim. The law prohibits unlawfully hostile work environments. And to be unlawful, the hostility has to be linked to a protected characteristic: age, race, sex, religion, disability, those sorts of things. If the hostility is due to one of those, then that would expose the employer to some liability. If it's just, I'm not happy working here, or this is a difficult working relationship because it's a personality conflict, or this person cheers for Green Bay and I cheer for the Cardinals, something like that, where it's not linked to one of those protected characteristics, then you would not have an unlawful hostile environment. If it is linked to one of those protected characteristics, then the hostility has to fundamentally alter the terms or conditions of employment. Does the person make less money? Did they get demoted? Have they lost out on some opportunities? Those sorts of things that would be looked at to gauge whether the terms and conditions of employment were compromised or violated. Is that going?
If I
Is that
can-
helpful at all?
Oh, sorry. And maybe just to follow up, even if some people do experience what they will call a hostile work environment, and it's real, it feels hostile. So even if there's not a legal claim, we certainly have had experiences of employees who may not be in a protected class, who are struggling at work because they do feel like they're not in a supportive environment. In fact, they feel like they're in a hostile environment. And so that can become an employment-related issue, whether or not there's a claim that can be brought under, with the EEOC or in court. So I think it's a real issue for people, whether or not they can follow up with some kind of legal claim, because it will necessarily have to involve your human resources department. It's sorting out relationships, because again, when people feel like they're being treated in a hostile way, it can impact their work product. It can impact their desire to come to work every day. And so it is an issue that can happen in the workplace, even when maybe there's not a legal claim attached to it. So if the question was asked in the context of social media, which I thought it might be, I think that's, again, a question to ask is, even if it's not defamatory, for example, is it still harmful, right? Is it still hurtful? Is it still damaging to relationships, to confidence in an individual who's an employee? Or, if a parent's looking at it and there's a negative post about someone who their child interacts with every day. So I think if that's the context in which the question was asked, then I think it's still a question to ask before one posts, right?
And
Thank you.
I'll just add a postscript to that too. When you're talking about hostile work environment claims, some things that matter from a legal point of view, you're asking, how pervasive is this? Meaning, how often does it happen? How often is this hostility present? Does the person do they say it every day, every time you see them, or is it once a month? How pervasive, how severe? And the more pervasive it is, the less severe it will be. the more severe it is, the less often it has to happen. So you're trying to figure out how pervasive, how severe in engaging a hostile work claim, and whether the hostility is coming from a supervisor or a coworker. The district is more exposed if the hostility is coming from a supervisor as opposed to if it's coming from a coworker.
Thank you.
Mrs. Fisher? Do you have any questions, Dr. Finch, at this time? Okay. So we haven't gone through much more than one or two questions, so.
I would generally prefer to go last because I find it's normally a will hold so that we can have our one say of what you said, and then you can't say anything in response. But I'm going to go and just read the questions to you that I have, and you can answer at will. Does the board have protection from hostile environment created from a position of authority within the district? That's number one. Number two, does the board work for the district or for the public who elected them? Number three, statute has responsibilities of governance throughout it that the board and board members are supposed to honor. Is it prudent for the board or board members to abdicate their responsibilities and rather serve as cheerleaders for the district through positive only? And then the final question is, oh heck, I just got derailed. The final question is, I wrote, well, actually it's just a statement. I do appreciate you going over this again. You've gone over it for us repeatedly, and this is all direct ASBA interpretation of statute. But if a board member is concerned, our policies are provided to us, then presented to us, then on consent without, in my opinion, full discussion. Is that problematic?
I didn't get the first question.
Okay.
Start with that one.
I think the first question was, is the board protected from hostile environment from staff? And of course, the civil rights, Title VII, the civil rights statutes typically apply in an employment setting. Is there some protection from a board member from a hostile environment? Probably so, in some limited situations. Of course, it'd be very fact-intensive, fact-dependent. I think the second question, Ms. Fisher, was does the board work for the district or for the public? And I think the answer to that is you do both. I mean, you are a public servant, but you have fiduciary obligations to Deer Valley Unified School District. You have a sworn oath you've taken on behalf of Deer Valley Unified School District. And so you do have obligations to both, in my view. I didn't catch the third question. The fourth one was, and Denise can give her, I'll answer this one, then let Denise say whatever she'd like. But abdicating, you raised an issue of abdicating responsibility. Do you abdicate responsibility and just be a cheerleader? No one's expecting everyone to agree on everything all the time. No one's expecting board members to just sell sunshine and roses all day, every day. There will be times when you disagree. There will be times when there are differences of opinion. It is how you go about expressing that we're trying to emphasize to the board tonight. There are appropriate avenues to do so. There are constraints that you've imposed on yourselves to do so, and those are well thought out constraints and reasons, and have been developed through a lot of experience and with an eye towards helping your students to be their very best. So no one is expecting anyone to abdicate responsibility and to just be a cheerleader. Obviously, you do this because you want Deer Valley to succeed and want to promote Deer Valley. But when there are differences of opinion, when you have a concern you want to raise, there are avenues to do that, proper ways to go about doing it. That's what we're, I think, trying to help help remind you of tonight.
In my last 41 seconds, the concern I actually have is that we've gone over policies that the board should follow, and the board should follow it letter by letter, and it's applied to the board when we don't necessarily have administration follow policy as well. And when you're on a, there's the old joke about the superintendent only has to count to 3. That becomes a concern. Is there an avenue to address that?
I think Rob already shared much. First of all, I wanted to also note that your board policy does provide that there is a board commitment that once the board makes a decision, a quorum of the board makes a decision, that there is an expectation that is reflected in the board policy that then that decision will be supported, even if there was a lot of disagreement in it prior to the vote. So I did want to note that. But in terms of the last question, Rob had previously covered the fact that if there is concern about the conduct of the employees of the district, if it's an employee other than the superintendent, then the expectation is that the superintendent is responsible for addressing those issues. If you're not satisfied with those actions, then you have the right to consider that when you're evaluating or considering contract for the superintendent. And if the unhappiness is about the superintendent, then again, as Rob previously noted, there's those opportunities typically by contract to have regular meetings or as needed between the superintendent and the board to discuss those relationships and those concerns. There's the evaluation piece, as well as, again, the ability to consider future relationships between the superintendent and the board and the district. So that's really the way things are set out.
Thank you. Mrs. Ordway?
Okay, I have a couple of questions and then maybe a little bit of help on how to carry out some strategies. So going to the social media and copyright laws, this is just like, because I go to, oh, I'm sorry, because I do go to as many events as I can possibly go to. And I do take pictures and I do post them, for the students so we can see how wonderful they're doing. So I'm just asking, is there a form I should fill out for that or not? And I do not do students' faces if it's not been verified that they can't be shown.
Yeah, that's a really good question. So, excuse me, remember that FERPA has a provision that talks about directory information. And oftentimes, and I think probably in your policy, student photographs are contained within the definition of directory information. And so what FERPA says is that at the beginning of every year, the district has a responsibility to send out a notice to all the families to ask them to opt in or out of directory information. Usually they're given 2 to 3 weeks to return the form. If they, return the form with the box mark, no, I don't want that information being shared, including photographs, then it shouldn't be shared. And there's good reasons for that. Sometimes people are protected persons, right? Abuse, et cetera, that they've fled from. I mean, there's all kinds of reasons why people may not want their kids pictures posted. So before you do post a picture, it's really worth checking to make sure the family hasn't opted out of that. And sometimes you also have even more specific consent forms for videos or photographs for particular events. It's not a lot of privacy interest in kids, if it's something that's open to the public.
Kind of like the homecoming
Right,
parade.
the football game scenario, okay, so that may be quite different. But it's nevertheless probably a good idea to check before you post discernible photos of students.
Yeah, I just wanted to verify that, so, just in case anybody else
Yeah, it's a great question.
is interested in that. So staying in the social media and then the defamation, so what happens if, or what do we do if the degrading or misinformed kernel of truth posts continue? And so what as board members are we supposed to do, whether they're about us or our employees? What exactly is what we're supposed to do? Or is this not the night that you're going to give us that advice?
Again, we'll answer general questions,
Yes.
absolutely.
Yeah, I was,
So defamation is a personal injury claim. So for example, if person A defames employee B has a personal claim because, they were defamed, they're injured, they've been injured. And they would, if they bring a suit and are successful, they would get an award, and that award would be theirs because it's a personal claim. And so there are some limits on the district's pursuing a defamation claim on behalf of an employee because it's a personal claim, and you are obligated to use your resources for public needs. But can you defend employee B from a charge? Yes. Yes, the district could. An individual board member would be unlikely to take that banner up themselves. That would be a situation where you would want to, report that concern and have it dealt with that way, I would think.
and certainly one step an individual could take is to notify the individual who has made a statement that is false, that it's false. Because again, in the social media context that you asked the question, there may be times that people just don't do the research that they should have done to determine the truthfulness or falseness of a statement, or an action by that other person that they're writing about. So it certainly could be appropriate to inform that individual that is false information, please remove it immediately.
Okay, and then, so going down that line, if it is consistent and it continually puts the district in a light that is by that opinion, is that where the insurance can say, hey, say it's something about our special ed department, they don't do this, they don't do that, blah, 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 or whatever the department is that something then that falls under that, or I'm just trying to figure that part out.
Well, I think defamation is about people, I wouldn't be necessarily about a department. It would be about a person or people.
Okay, so a person in our department.
Okay. And again, I think, if we're going to go into any, whether it's perhaps theoretical at this point or not, I don't know. But this may be a topic that's probably better discussed maybe
We can follow up.
session if
related
it's
to
more
this.
detailed.
No, you're out.
So,
Okay, thank you so much,
Yeah.
Denise and Rob. Dr. Finch, did you have, you're good? So you can start the time for me because this will be my 5 minutes. Thank you. I want to thank our board members for requesting this session and for our two attorneys who provided the information. We have a board member on here who's been serving for less than a year, all the way to a board member who I believe is in her 13th year, and everything in between. Every time I hear one of these, I learn something new, or I'm reminded of something that sometimes is just you don't think about as often as you might need to sometimes. So I appreciate all of the information that we received, appreciate the good questions from our board members, and I hope our community will take the opportunity to watch this meeting, because I think that there's a lot of information in it that you don't normally, they don't get a chance to hear about related to board work. And so I think that's also important for us as board members, is try to educate our community members as it relates to some of the nuances of being a board member. And, you don't always, it's not always about just what you see at the dais during the meetings, or when we get to run into you at the football game or a grocery store, or wherever else we might run into you. So I do appreciate that, and I think this was helpful for us all. And if we have any specific questions, I would encourage that you board members to send them to Mrs. Taylor so that we can deal with them offline under the umbrella of attorney-client confidentiality. And with that, I certainly would entertain a motion for adjournment.
I would make a motion that we adjourn at, I think it's 8:23.
8:23. Second?
Second.
All those in favor?
Aye.
Aye. Any opposed? Hearing none, the motion carries unanimously.